The next case that we will hear, if you are both ready to proceed, are you? Okay.
I'm ready, yes.
Is the state of Ohio v. Donald J. Buchs. You will both have, again, 15 minutes to present your arguments. The appellant may reserve up to 5 minutes for rebuttal, and if you do plan to reserve time, please let me know, as I'll be keeping track of time. Your arguments are being recorded. Again, keep your voices up and stay behind the podium. You should not use the names of children, minors, and victims. You can use generic terms or initials. And I assure you once again that the judges have read your briefs and are ready to proceed when you are. And Attorney Brunke, would you like to reserve time?
I would like to reserve 5 minutes of my time. Thank you. Again, good morning, judges. Giovanna Bremke on behalf of Mr. Donald Buchs. Mr. Buchs was indicted with 10 counts after a tragic accident. He was sentenced to 11 years in prison and later filed a motion for post-conviction relief, which was denied in a very brief entry without any hearing or any findings of fact.
I think the parties agreed that that motion was untimely, correct?
No, I don't. I will address the timing issue, and I can start with that. It was outside of the 1 year, but the argument is that he was unavoidably prevented from discovering these facts. So there was affidavits attached to the motion which indicate that Mr. Buchs and his family had actually been longtime friends of the attorney who represented him, but that the attorney, and it's very sad, but he, and it goes through my motion about how he had his own criminal charges. He was found not guilty by reason of insanity. He has severe advanced dementia and has since the Ohio Supreme Court has indefinitely suspended his license to practice law. Even with his relationship with the attorney, he was unavoidably prevented from discovering the facts that led to his ineffective assistance in the matter.
I'm sorry, I, from the briefs, couldn't understand. There's some reference in the appellee's brief about a second lawyer involved in the case at sentencing. So were there 2 lawyers for the whole proceeding, or did one lawyer take over? Did Mr. Buchs have 2 lawyers during the proceedings?
So the record's unclear to what extent that second lawyer played in the proceedings throughout the entire time. But he was there at the sentencing hearing. I would submit to you that neither of the attorneys had provided any kind of valid defense, and that was part of the post-conviction relief motion at the sentencing hearing. That Mr. Buchs in the affidavits provided by him and his father, and they were in on the conversations. It's unclear again whether that second attorney was in on those conversations, but he was provided 5 years. He'll get 5 years. So whether that attorney that attorney didn't dispute that, I guess, and that's sort of the crux of it. He believed he was getting 5 years. He ended up with 11 years.
Did the judge explain to him the maximum potential penalties?
I believe that was, yes, part of the plea. I won't dispute that. But that is, the argument is that he was ineffective because his attorney had provided him, hey, if you plead, you get 5 years. And the other cases that I've cited that this attorney had represented the individuals, and the trial courts have overturned those cases, it was the same issue where they go for the day of trial, and the attorney, again, because of his advanced medical and mental condition, was not prepared and not adequate for trial, and he knew that and would pressure people into pleading by making them promises that weren't the reality. And so, although the trial court judge...
But with respect to, you're not contesting anything related to the court's interaction with Mr. Buchs, related to the colloquy and going through all of that with him appropriately. Is that correct?
Yes, but I am disputing the court's finding without the hearing or the findings of fact on the post-conviction relief. But as to the plea in the sentencing hearing, I think that's what you're asking about, and no. But I think, and again, Justice Donnelly, the Supreme Court, has repeatedly talked about this idea of sentencing by ambush, and the fact that trial courts have these conversations with attorneys and without the defendants in back behind chambers, and that there's these promises or there's these representations, and what gets back to the client is unsure, and how that affects someone's plea to be knowingly, intelligently, and voluntarily made. And in this case, it speaks directly to that. He received this promise of 5 years from his attorney, which is corroborated by his father, who was there during that conversation. And that's why he entered the plea. That's his knowingly, voluntarily, and intelligent plea, and then later sentenced to 11 years. So while the colloquy may be correct, there is this idea of this sentencing by ambush, which this is directly a sentencing by ambush, in my opinion.
I'm going to direct you back to the unavoidably prevented part.
Sure.
So this plea and sentencing occurred in 2018, and now we're here in 2023. The post-relief conviction petition wasn't filed until 2022. Am I correct on that?
I believe it was either, you're probably right, 2022.
So why wouldn't he know that his lawyer has these kind of problems, or that what's the facts there that would prevent him from not being able to raise the issue before?
Well, I think the issue is that the attorney didn't become suspended from practice until later, until around this, it was just actually, I think, right around the time I was filing this brief, he was permanently suspended, he was on a temporary suspension, and so it wasn't until then, and again, these other cases are coming out where he's realizing that his attorney did not want to go to trial because of his own mental capacities, that he wasn't able to, and in like any medical condition, at some point it takes a sharp decline, and that's what happened in this case.
Well, in 2018, your client should have known he was, in his view, promised to get 5 years and got 11. And so that area you're complaining about was well aware of your client back in 2018. He could have moved to withdraw. He could have filed a post-conviction rescind. He did not.
Well, I disagree with you to a certain extent, because the contention is that it was a direct result of the attorney's mental condition, and that wasn't aware until later. So while he knew he didn't get what he promised, it wasn't believed to him that it was as a result of the attorney's medical condition and the attorney's repeated attempts to force individuals to plead because he knew he wasn't at the right mental condition to proceed to trial, and promising them things that he couldn't deliver. That was when, that's sort of, in my opinion, when it starts the time clock.
I have another question as well. With regard to the post-conviction relief petition, was there any affidavit attached by an expert? I'm going into another subject here about the marijuana issue, because you talk about studies with marijuana and sobriety and impairment and in relation to the defendant's level, but are there any experts in the affidavit, or are there any affidavits attached to the post-conviction relief petition that are specific with regard to the defendant's case?
No, there was authority cited, but no affidavit cited by an expert. And I want to just a little bit more to the timing, and also to my issue about with the court not making the findings pursuant to my first assignment of error. The Ohio Supreme Court has given all of us a lot of guidance, and sort of rapid fire guidance at the end of the year last year. And that's why I filed 2 motions to supplement with supplemental authority in this case at the end of last year, or early this year. And that's the Hatton and the Bunch case. Now, both of those, Hatton, his motion was filed 20 years later, and in Bunch, it was nearly 20. It might have been short of 20. But certainly, the timing issue was much later on.
But Bunch, they considered a timely petition, correct? Because he was resentenced. And he actually made a post-conviction relief petition timely before, and it was supplemented. So that, I don't think that one is relevant.
Okay, well, in Hatton, it was definitely 20 years later that he had made the motion, and I don't believe in Hatton there was any subsequent motion.
It was untimely, it was unavoidable,
Correct.
unavoidably prevented because there was a new letter from an expert.
There was some additional testing, I believe, in that case. In my case, there was no trial, so, I'm, you know, but there's still this plea, and again, that's, you know, my contention is that it wasn't knowingly, intelligently, voluntarily made because of that. And for that reason, I think that he should get the opportunity to have that expert, upon, you know, a review. But again, the Ohio Supreme Court has sort of rapidly fired, given us these opinions, and they are, what I think is sending a very clear message that they want these hearings. They want to hear these things on their merits, and not just, you know, and not just summarily dismissing them. And that's what this judge had done. And 2953.21H is sort of what controls in that area, and permits or mandates that if the judge doesn't find grounds, that they should be making findings of fact and conclusions of law to support the denial. This court did not do that. I would,
You are headed in.
I will reserve the rest of my time then, thank you.
Thank you. Again, I'm Rick Raley on behalf of the state of Ohio in this case, and my more familiar place as the appellee. I want to jump off on just a comment that Ms. Bremke made, and that is there was no trial in this case, because that's extremely significant. RC 2953.23A, unavoidable prevention. You have to show there was constitutional error at trial. There was no trial. That cannot be satisfied. Really, so all these discussions of experts, anything related to merits, really the court couldn't reach them, and this court can't reach them. So really, that is the most important issue this court to consider in my view.
And so were there trials under supplemental authority then too?
Pardon?
The supplemental authority that she added Brunch and
Yes, my understanding is there were
we
trials.
both had trials.
Yes. And so I'd really then go back to the first assignment of error, which relates to the lack of findings of fact. There's pretty clear case law that an untimely petition may be dismissed without the findings of fact. And the defendant's reliance on 2953.21D is really misplaced. That statutory provision refers to timely filed petitions, which this is not. So really for that, the court properly determined that it was untimely and dismissed the petition and did so without findings of fact. So if there really are questions about those procedural issues, I think those are the unsurmountable barriers that have to be overcome. Thank you.
Thank you.
You threw me off there. Okay, well, since my colleague made such a quick appearance, I don't have a lot to say off of what he said, but I would just reiterate again, 2 assignments of error, number 1 being that there are, that the court didn't make any findings of fact and conclusions of the law. I submit to you, they had to. The Ohio Supreme Court is sort of begging us to have these hearings, in my opinion, with these recent cases, and an overall trend. Even the Supreme Court in creating the Conviction Integrity Task Force Unit, they're saying, hey, let's review these on their merits, and that's what I'm asking for in the first assignment of error. The second assignment of error, again, that the timing is an issue, but that he was unavoidably prevented from knowing that his attorney was suffering from this severe mental condition. Again, a mental condition that's left him to the point where he couldn't even defend himself in his own criminal case. He couldn't even help assist his attorney to represent him in his own criminal case. And I forgot to mention when Judge Flegg-Lanzinger brought up about that second attorney. That attorney, and there's a note of it in my brief and also in the post-conviction relief motion, that attorney actually represented him in his criminal matter, and there's sort of an assertion in my brief that he relied on this attorney because his own mental faculties were deteriorating. So you'll see that neither of them made much of a defense, but that's another indication that his mental capacity wasn't there, because he has this attorney who later represents him because of his mental capacity, who is there as sort of, part of the mental capacity of himself.
So is it your argument that the second attorney also had some deficiency?
It's my argument that that attorney really wasn't acting to represent Mr. Buchs, but was acting as sort of a support for his primary attorney.
Is that what the record is gonna reflect when you look at that?
The record does not make it clear what that attorney's role is. But that attorney is at the sentencing hearing where Mr. Buchs gets surprised by this long sentence. And that attorney does not present a defense on behalf of Mr. Buchs, so that's my contention that he wasn't he wasn't representing Mr. Buchs, he was there as a support person.
Thank you.
Okay, so I would ask again that you overturn the ruling of the trial court and reverse it either for them to make further findings of fact or on the actual merits itself. Thank you.
Thank you both for your presentations. The court will take the matter under advisement, issue a decision in due course. The clerk of courts will mail a copy of the decision to you on the day it is released, and it will also be posted on the Ohio Supreme Court website.